Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics.
All right, I'm here this week with Carleton University's Professor Philippe Lagassé, and with all of the foreign interference talk, one of the subplots has been the fact that NSICOP, the National Security and Intelligence Committee Parliamentarians, is not a parliamentary committee, it is an executive committee made up of parliamentarians. There were reasons for doing it this way. Some of them had to do with intelligence agencies not trusting MPs. Some of it has to do with the fact that there were no secure meeting areas on Parliament Hill, which I know Phil and I have talked about for previous articles. So I figured we would chat a little bit about this and what some of the challenges are in one day, maybe sooner than later, turning NSICOP into a parliamentary committee. Phil.
Thanks, Dale. Thanks for having me. It's an important topic.
You had a piece in the line this week about this, and why don't we just walk viewers through what your argument is here?
Okay, so whenever I've written about the NSICOP or transitioning NSICOP into a parliamentary committee as opposed to a committee of parliamentarians, I tend to get responses from either former members of the public service or others, emails saying, "How can you say this? How can you possibly give this information to parliamentarians? That would be so incredibly irresponsible. You need to put measures in place and do whatever you need to do in order to secure that information. And it's not only important for the information itself, it's important for our reputation amongst allies and so on and so forth."
Yeah.
And I've heard that in numerous settings. And while I acknowledge it and I understand its importance, it's also important to recognize that when we look at this from a comparative perspective, that not only can you share information with parliamentarians, but it's routinely done, including in our sister Westminster states. So the purpose of the piece was really to say, okay, as a country, we already have a real problem when it comes to secrecy of information, and we don't have a culture of transparency in Canada. We have a deep-seated culture of secrecy. It affects not only our broken access to information system, but the general way that we kind of apply cabinet confidence to many things that shouldn't necessarily be considered cabinet confidence. And by the same token, our reticence when it comes to bringing the legislative branch of the state into the national security community to ensure proper oversight is really difficult in Canada. So we really keep classified information within the confines of the executive, or in some cases, the judiciary, but we're very reticent when it comes to the legislature. And I would argue that over the past 2 decades, we keep bumping into this issue. Yeah. And until we resolve it, we're just going to keep coming to these same confrontations. And we can get into that if you'd like, but that's the background really of what we're talking about here.
Okay. And it would seem to me that the very existence of NSICOP and the fact that for 5 years it's done its work with nobody has spilled any secrets out of NSICOP would seem to disprove your critics.
Right. So NSICOP was always understood to be a compromise at the beginning. Right. In the same way that when the Intelligence and Security Committee of the UK was set up, it was also effectively an executive body, and it gradually transitioned into a parliamentary one. And we decided, understandably, because we weren't used to this yet, that we were first going to set up this body within the executive to get the intelligence community used to being overseen in this way. And it's not just a cultural thing. It's also, I don't think people realize the extent to which you have to set up entire kind of bureaucratic bodies to feed these 2 new committees that we created. Yeah. So you have to build up this institutional capacity to give these people the information that they need. And by the same token, you had to create, pretty elaborate secretariats that help NSICOP do its work, that help NCIRA do its work. And this may be one of the issues that we'll run into when attempting to make it a parliamentary committee, but we can leave that aside for a second.
Yeah.
But the idea was, right, let's kind of first do a test run. Let's get everybody used to this and see how it goes. But as you say, it's now been 5 years. Nobody on the committee has revealed any classified information. Some people may say, well, that's because Section 12 of the Act that created NSICOP waived the privilege of members to disclose what they learned in proceedings in Parliament without facing charges under the Security of Information Act. Mm-hmm. As it stands, though that section has been deemed unconstitutional, that's now on appeal. Yes. But the fact remains, right, that it's been very successful in its test run. In terms of in terms of not disclosing classified information. So maybe it's now time. It's at a 5-year review. Let's see if we can make the next transition and make it a full-fledged parliamentary committee.
Okay. And just for viewers, I wrote a piece on that court challenge around the privilege aspect, and I can link that below for people to check out. But again, this is one of the things that I wanted to touch on is this notion that if it were a parliamentary committee, that privilege would not be an issue for it. My understanding is that in comparative Westminster democracies, there are still abilities to fetter privilege for their intelligence and security committees.
Right. I personally was very surprised by the ruling that found Section 12 of the NSICOP Act unconstitutional. I personally don't think that's correct. And while I respect the argument, mm-hmm. I don't think that it really stands up. And I can't wait to see what's going to happen on appeal, because you even have the speakers of the two houses arguing against the ruling, saying one of the core privileges of the houses is that they get to determine their own privilege. Yeah. Right. So, and this is important because it's important to recognize that privilege is collective first. Yeah. Right. So in other Westminster democracies or in other settings, parliamentary privilege in this context is understood somewhat differently, because what it does is it allows the houses to sanction members that misuse information. Right. And you would not want to be in a situation where the individual privilege of speech is somehow constitutionally protected against the collective privilege of sanctioning the member. So it's important to always bear that in mind, that this is very complicated. And I don't anticipate that this is that this ruling is going to survive, to be honest.
Okay, and that's good context to have in terms of this knowledge or this notion that MPs could use privilege to disclose classified information because they've got that protection. It ignores the fact that in doing so, they invite Parliament to sanction them for breaching privilege or for breaching their oaths in that particular way.
Or simply for misusing the information that they've been given. For the House can sanction its members for whatever it believes is necessary, right? Yeah. And it's also important to recognize that this is a very different kind of Canadian approach to privilege, where again we tend to view it as through the prism of the individual member, whereas in other jurisdictions it's viewed differently, because it really is viewed as the ability of the houses to manage their own affairs, and therefore, there would be no question, right, that the houses would be able to deal with this. So to your point, when it comes to other jurisdictions, it's not like they're a free-for-all. Yeah. Right? There's tons of protections that are put in place. And it's well understood, right, that these committees have to have safeguards, they have to have protections, they have to operate in a particular way. And that's what ensures their success. And we could replicate that. It's just a question of how.
Okay. One of the other issues that comes up is the issue of redactions, and NSICOP's reports need to go through a process to ensure that no classified information is revealed as part of their report. And again, there seems to be this notion that if we had a parliamentary committee, that those reports would not still go through that executive process for redaction. And my understanding, again, is that is not exactly true.
No, I mean, it's even though the UK has a parliamentary committee, there still has to be an agreement with the executive about what the reports actually include. And fundamentally, these committees, even when they are parliamentary, tend to be tacit agreements, right, between the legislature and the executive. The New Zealand one is the best example, where you have the chair as the prime minister.
Okay.
I mean, okay, the chair of that parliamentary committee is the prime minister, and the leader of the opposition sits on it. Now, there's a New Zealand report recommending that they remove the leaders from the committee to make it more legislative. But the point is that they've always been understood as this kind of bridge, and they fundamentally rest on a cooperative approach to national security between the parliamentary body and the executive body. And in a sense, right, this is why I keep, and some others keep pushing for this. Like, we need to get to that level of maturity.
Mm-hmm.
And we're not there yet, and there's a chicken and egg problem here, where you say, well, our partisans are just absolutely ridiculous in this country, which is true. We're surrounded by meathead partisanship of levels that are unknown and unseen in Canadian tradition. I mean, it's just beyond the pale these days. But the only way you're going to get out of that at one point, right, is by actually shaking people up and making them serious about serious issues, right? That's my view.
Yeah, and it seems to me that this is actually one of the things in the Johnson recommendations in bringing in the opposition leaders into being able to see the documents, is to ensure that it kind of forces them to grow up and have a mature debate about this. And they're resisting doing that because they don't want to be forced to grow up in that way.
No, absolutely. I mean, we should have it as a standard practice that leaders of the opposition become privy councillors and are briefed on significant national security matters as a matter of course.
Yeah.
And why do I say this? Simply because issues like this should not be kept solely within the executive and stir controversy, as we're seeing, right? That then makes it a partisan issue that should be a bipartisan national security issue.
Yeah.
Now, again, chicken and egg problem. The leaders of the opposition may refuse to get briefed. They don't want to get briefed. And we're seeing this right now. They don't want to, quite simply because it's not that they wouldn't be able to disclose anything. It's a much more comfortable position when you're in opposition to just be able to lob rocks and not have to, be aware of what you're talking about. There's an immense power in ignorance, right?
Yes.
When you don't know what's at stake, it's very easy to just be asking questions, right?
Yeah.
So, but here again, we need to get down this path where this is something that we start doing as a matter of course, and there's going to be some growing pains, but before issues become scandals and controversies. This is what you need to do to stem that, to make sure you never get there, so that they're briefed on it before it ends up in the Globe and Mail, and therefore, the controversy around it is less evident. So you can imagine, in this case, how much less controversial this would be if the leaders of the opposition had been briefed on this years ago and had been working with the government to deal with it, as opposed to finding out about it and now trying to make a partisan point gaining exercise.
Yeah, for sure. Going back to the issue of the kind of bureaucratic infrastructure and so on of creating this kind of committee, one of the notions is also having secure places to meet for this committee. And my anecdote is always that the center block was so bad for noise escaping that they had to close off washrooms on caucus day, because otherwise you could hear what was going on in the caucus room. And that's kind of an indication of just how there just weren't any kinds of secure places for a committee like this who could meet in those facilities. So let's talk a little bit about what needs to happen if we were to get to transition.
Okay, so anybody who's gotten a security clearance in Canada kind of knows the drill around this. You need to be able to identify how documents are labeled, and therefore what those labels indicate, and the level of clearance that they indicate, and where and how you're able to consult them, and where you're able to store them. Mm-hmm. Now, this isn't something that you just do on the fly. I mean, this is deadly serious, right? Yeah. You need to be able to know, like, okay, what this document is and how you use it and all the rest of it. So already right there, right? You need training of personnel that would assist this committee alongside the members that would need to understand this. So you can't just have kind of regular parliamentary staff, regular clerks kind of cycling in and out. I mean, you would need to have people that understand this thoroughly and understand how it works. Similarly, you then need the IT systems and the physical infrastructure to store this information and anything that derives from that information, right? So it's not just the documents itself, it's any report, analysis, or whatever it is, needs to also be properly secured. Now, you then finally need what's known as a SCIF. So it's a secure facility to consult this type of information. You would need to build that somewhere, particularly if you want to make it truly parliamentary. Now, there's probably an ability to say, okay, within the legislation, for the purposes of this committee, a SCIF, at 101 Colonel By, which is the National Defense Headquarters, the former one, like that could be used. It's not far from Parliament, or you could presumably there's one in the Prime Minister and Cabinet's office. I don't know where all the locations are. The point is, you would either need to build one within the parliamentary precinct, or create it such that it's understood that this committee, if it becomes a committee of parliamentarians, can use this. But it's as important. Again, it's not just the parliamentarians. It's the people around them and the people who are going to be supporting them that needs to also be properly indoctrinated in terms of the use of this information. And this gets back to your previous question about classification and redaction. Like, I think there's this assumption that somehow people working in Parliament are going to be making these determinations. They can assist, right, with the proper training, but it has to be a dialogue between the executive and the legislature.
Yeah, and that's been a real issue around things like the Winnipeg lab documents, where the opposition has demanded that the parliamentary law clerk do the redactions, which is mind-boggling because he doesn't have the security training to know anything about that.
Yeah, let's be very clear about this. I think this is where there's a lot of misconception. The classification of information and the granting of a clearance to view that information is a purely executive function. Classification of information is executive.
Yeah.
Security clearance is not a parliamentary thing. It is an executive thing. Security classification is an executive thing. It doesn't make sense in a parliamentary context in a way. It's almost alien to it, which is why in other jurisdictions, such as Australia, the Parliamentary Joint Committee on Intelligence and Security, the members don't have clearances. Just because it's just understood, right, that if you're a member of this committee, you're going to take this seriously and you're going to do your job properly. And they may have it based on their previous executive experience, but it's a different view of it. So in the same way, right, that it would make absolutely no sense for a parliamentary officer or employee or whoever to do a function that's uniquely executive in nature. It has to end up being this dialogue between the two, where somebody with training within the parliamentary context could say, okay, the members of this committee believe this is vital or should be in it, and then the person with the proper training and the understanding within the executive says, okay, here's our point of view. And as we see in the UK and as we see in the NSICOP legislation, this ends up being a discussion between people around the Prime Minister and members of that committee, and they have to go back and forth until they can land on a general agreement. And you know what? That's good. That's exactly the kind of common understanding of these issues that we need to build.
Yeah. All right. I think we're kind of running up on our time here, but this has been a super fascinating discussion, and I'm hoping that we can talk about this more in the future. So thanks again, and we'll talk soon.
Thanks, Eb.
Take care. All right.
And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. It's at journo_Dale on Twitter. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.